They're trying to speedrun justice like it's a PR stunt, and Jack Smith's office is right in the middle of it, pushing a timetable so fast it looks less like a fair trial and more like a railroad job. We're talking mountains of evidence, endless hours of footage, overlapping cases, legal landmines everywhere. And yet the message from Smith's side is basically, it's fair, trust us. The judge will decide, and the public deserves speed. That's not reassurance, that's a script. And when you start hearing that line on repeat, you can practically picture the scene behind the curtain. Staffers sweating, phones buzzing, lawyers panicking, paperwork flying, everyone trying to keep the timeline on track while pretending the defense can somehow digest a documentary-sized discovery dump overnight. Because when the schedule is the story, it's usually because somebody's trying to outrun scrutiny. But here's the problem. You can't lecture the country about fairness while shoving a case through the system like you're afraid of daylight. And in just a moment, you're going to hear Jack Smith himself, because the next clip has shocking details that expose exactly how this timeline is being sold to the public. Before we roll it, smash like, hit subscribe, and let's break this wide open.
Initially, in the documents case, sorry, not the documents case, the DC election case, how quickly did you want to proceed to trial after that case was indicted? What was the time frame, if you remember?
I know we requested a trial date. There's a public record of this. Right. I think the judge had a status conference where we discussed it. We proposed a date. They proposed a date in 2026. The date that the judge chose was not the date that we proposed, but was, I think, 2 months after the date we proposed. Right. I'm going to say I'm going to guess 4 months, but there's a record of that. Right.
Yeah, I think the special counsel's office proposed initially trying President Trump in January of 2024. The judge, Judge Chutkin, came back with the Super Tuesday date, which of course raises a whole other set of questions which aren't necessarily directed to you. But do you think in hindsight that, I mean, how many months, was that 4 or 5 months after when did the indictment drop? Was it August?
The indictment was in August.
August 1st of 2023?
Thereabouts, I don't remember the exact date.
Okay. So we're looking at 4 months or 5 months, depending on when it is in January. That's a pretty aggressive timeline, isn't it?
We organized the discovery in a way that we felt that was a fair date.
Do you remember, as you sit here today, how many pages of documents there were for that case?
I don't.
Okay. Does the number 13 million? I mean, if I told you 13 million, would that be something that you would sounds about right?
Again, I couldn't say.
And how many witnesses did the defense need to digest? How many possible trial witnesses did the defense need to digest?
I don't think we got to, because the court obviously didn't accept that trial date, so I don't think we got to that question.
And how many hours of video footage?
You mean like footage at the Capitol of the attack on the Capitol?
Just how many hours of video footage? If the defense was going to take that to trial in 4 months, how many hours of footage would they need to digest?
I'm just trying to think if there was any video footage other than the footage of the attack on the Capitol. I can't answer that.
President Trump's defense team, indicated that it was like thousands of hours of video, and so to digest thousands of hours of video, to digest 13 million pages of documents, would have put them in a situation to, either A, not review the documents, or B, they're looking at like reviewing 100,000, pages per day. I mean, do you think that's reasonable?
I thought the trial date that we proposed, given the case, given the discovery, was reasonable, yes.
So if the math works out that they had to digest about 100,000 pages a day, you think that's reasonable?
I don't know if that's the math, and I don't know if that's the proper way to measure it, but I do think the date was reasonable.
And while all this was going on, we went into this a little bit before, but you have the DC case going on, you have the Florida case going on, and you know that President Trump is required to be in Manhattan for the District Attorney of New York case. At any point in time, did you stop to think that maybe you should have given him a little bit more time to deal with all these cases, these competing cases?
Well, we thought through the dates we asked for. We thought they were reasonable. We also deferred to the judges. So when we asked for a date and the judge picked a different date, I don't recall that we objected to that date.
A lot of times, though, the judge just splits the baby, right?
Well, I don't know that that's always the case. Sometimes they pick the date that one party says, sometimes they pick the other, sometimes it's in the middle, so.
Yeah. Judge Chutkin certainly picked a date closer to yours than the 2026 date. Getting back to the Robert Jackson, statement that I read this morning, he concludes that a sensitiveness to fair play and sportsmanship is perhaps the best protection against the abuse of power, and the citizen's safety lies in the prosecutor who tempers zeal with human kindness, who seeks truth, not victims, who serves the law and not factional purposes, and who approaches his task with humility. Do you think, in hindsight, that you exhibited the kindness in dealing with President Trump that Robert Jackson evinces here?
I think in our conducting both of these investigations, we did it consistent with the best traditions of the department and the principles that Justice Jackson was talking about there. So yes, I do think in both cases we adhered to those principles.
And is it also fair to say that you were, in fact, trying to get these cases wrapped up before the election in 2024?
We were trying to move these cases expeditiously. In our briefs, we cited to repeated Supreme Court precedent that states that the interest in a speedy trial, the right to a speedy trial, isn't just the defendant's right, it's the public's right as well. And given the gravity of these crimes and the public interest, it was our duty to move them forward as expeditiously as we thought fair and reasonable.
Okay. So in hindsight, there's nothing about the aggressiveness of your schedule that you would have done differently?
I thought the schedule was appropriate.
I just have a couple other questions. I'll jump around and then I'll be done. Hopefully I can do that very quickly. The Florida case, initially you had a grand jury operating in Washington, D.C. How does that work? You're taking evidence in D.C. for a case that you ultimately decided to venue in Florida. Were you able to use the material from the grand jury in D.C. for the case, or did you have to repurpose that? Did you have to recirculate that material through a grand jury in Florida?
Mr. Castro, I'm sorry, I'm a little concerned that questions about the grand jury in D.C. and the Southern District of Florida may implicate both 6E issues and the scope of Judge Cannon's
fair
order.
enough. Can I ask hypothetically then, if you have a case that you're operating a grand jury in the District of Kansas, and you decide to move a case to, the Central District of California, how would you ordinarily? What's the department's posture on that?
In what sense?
So you have a grand jury operating in Kansas, and you collect evidence. Are you allowed to use that evidence if you ultimately decide to venue a case in the Central District of California, collected in Kansas?
Yes.
Okay. And are there any concerns about that?
You're speaking about a hypothetical case, but I think we're kind of speaking about the case in Florida, and so I think whether there would ever be concerns depends on the specific case we're talking about. And again, I don't feel comfortable answering that because of this injunction, but for the injunction, I'd be happy to answer it.
Okay. Mr. Jordan wanted me to point out that there was a discussion earlier, I think it was with Congresswoman Scanlon talking about the Pennsylvania election. And you, I think you used the term that, in the normal course of things, the, things that happened in Pennsylvania. Am I jogging your memory with this?
I know we spoke about that.
Mm-hmm.
There was another series of questions about this, so I do remember that, yeah.
Okay. And we just wanted to point out for the record that, there was nothing normal about what happened in Pennsylvania during the 2020 election. The state legislature, who ordinarily is responsible for making, the election law, picking the time, place, and manner, and prescribing the blow-by-blows in an election, was, basically usurped by the Pennsylvania Supreme Court. And they changed all sorts of things in the 2020 election. For example, they said that the election, instead of ending on, ordinarily would end on a Tuesday, election day, was going to end on a Friday. The Supreme Court said that where signature verification was ordinarily required, that was the Pennsylvania state legislature's, that's how the statute's set up, in terms of administering elections. And the Supreme Court changed that and said that, signature verification wasn't required. The volume of absentee ballots was completely different than an ordinary election. There were over 2 million, absentee ballots. And so, we just wanted to point out, and I guess ask you the question, were you aware of all these irregularities and disparities because of the COVID and so forth? So many things had changed by the time it got to election day in Pennsylvania.
Well, what I can say is that some of the issues you raised are the sort of issues that a campaign or someone who's a candidate can raise in the courts, and I believe a lot of these issues were raised in the courts. I think Donald Trump lost those litigations, and as we pointed out in our indictment, that bringing a lawsuit for some of the issues you talked about, that's the proper way to dispute these things, or asking for a recount, as President Trump did in 2 states. Our case was about false allegations of fraud. Our case, the things you just mentioned, we didn't allege those to be part of the fraudulent conduct targeting a government function. And so, again, those are issues that I think we were aware of in studying these things and in speaking to election officials there. But they're the sort of issues that are dealt with through litigation in our court system, and I think that's what happened in the election after.
Okay.
If you watch this whole thing and you're still not furious, you weren't paying attention, because what we're seeing here isn't efficient justice. It's a system being pushed like a shopping cart downhill, and they're calling it fairness while the wheels are wobbling. They want you to accept a timeline that feels designed for headlines, not for truth. They keep repeating the same soothing talking point. We think it's fair. The judge decides. The public deserves speed. Like a magic spell that makes the basic math disappear. Mountains of evidence, overlapping cases, and a defense team expected to sprint through a blizzard of discovery without tripping. That isn't confidence, that's pressure. That's a squeeze. And here's the part they hope you'll ignore. When people in power start acting like the schedule is more important than the process, it's usually because they're trying to control the story. Not let the facts speak, but force the facts to keep up. A fair trial isn't a race, it's a test. And when one side is obsessed with the clock, you have to ask why. Are they afraid the public will notice the shortcuts? Are they worried the contradictions will surface if this drags into daylight? Because the louder they insist it's fair, the more it sounds like they're trying to convince themselves. So don't just watch and scroll away. If you want accountability instead of spin, you have to back the people calling it out. Hit the like button so this gets pushed into more feeds. Subscribe because we're tracking every twist, every excuse, every trust us line they try to sell you, and drop a comment. Do you think this timeline is justice or strategy? Share this video with someone who still believes power always plays fair, because the only thing that stops a machine like this is an audience that refuses to be gaslit.